Hello, everyone. Good morning, good afternoon, good evening. I'm Professor Heng Wang, co-director of the Herbert Smith Freehills China International Business and Economic Law Center at UNSW Law Justice. And I'm very delighted to welcome you to the CIBEL's Global Network Young Scholar Workshop on changes in international economic law, digitalization, sustainability, and beyond. And I begin today by acknowledging the tradition, custodians of the lands on which we meet today, the Betago and Gadigal people, for where UNSW stands, and pay my respects to the elders past and present. I would also like to extend that respect to other Aboriginal and Torres Strait Islanders who are joining us today. And for today's events, we're very excited that to have invited upon a number of the great scholars, in the areas of investment law and also sustainable development to discuss a very important and also increasingly important issue of what are the changes we're facing in international economic law, particularly from the perspective of the international investment law, as well as sustainable development. As you will see later in our discussion, that we'll be able to discuss a very important issue ranging from the conceptualization of international investment law to legal stability and renewable energy transition, as well as issues like environment, governance, and investment law. And this year we have our events, which has been, trying to facilitate the more discussion on those kind of really important issue. Therefore, over the past few weeks, our young scholars have provided us with video presentations, which thoroughly explain their research insights. This can be found on the Sable website. With this in mind, today I will introduce each young scholar right before they speak, and they will be summarizing their research in 5 minutes. And our commentator, Jonathan, will then speak, and followed by a roundtable discussion, Q&A, and finally, we will announce the winner of the Sable 2022 Young Scholars Prize. So now I'm very excited to move to the first speaker, the Dr. Dominik Moscvan, the research scholar of University of Antwerp. And he is a legal expert at the European Insurance and Occupational Pensions Authority. He obtained his PhD from the Faculty of Law of the University of Antwerp, and he also holds a Juris Honoris doctor degree in European Union Law from the Charles University, LLM in the International Business from the Tilburg University, and a master's with the Tilburg University Merit Scholarship awardee, and a master's degree in law from the Maastricht University. During the course of his doctoral study, he was a visiting researcher at the University of Oslo and Peking University. Dominik gained further experience working in various legal roles at the European Commission's Legal Services, the International Monetary Fund, the Energy Charter Secretariat, and the Czech National Bank. His research interests lie in the areas of international European economic and financial law. Dominik's topic today is a conceptualizing investment in international law and framework proposal. So now I'd like to invite Dominik to share your thoughts, and thank you.
Thank you so much for the generous introduction, and most importantly, thank you for having the possibility to share my research, which I'm immensely grateful for. My paper is aiming to fill a vacuum in the international economic law about the lack of a universally accepted legal definition of foreign investment. And it does so by proposing a unique framework which would conceptualize investment in an unbiased and inclusive typology. So far, legal definition of investment was either designed for with a particular national interest in mind when designing an investment treaty, or suffered from the lack of coherence when an arbitral tribunal would issue an award. The impetus for the paper and the underlying question that I ask is as follows. If economists share a universal understanding of economic motives, why investors invest abroad, would there be a legal framework which would capture the same, with legal motives to understand legal behavior of investors? Next slide, please. The framework puts investor interest in the center. This is for two reasons, which are intertwined. First, it's economic legitimacy, and that is that the conceptualization of foreign investment proposed builds on the essence of investment interest, which lies in the very decision of why a natural person or a legal entity would conduct a cross-border business activity, and that is to pursue profit. So that is the economic legitimacy, and it reflects economic reality. At the same time, in exchange for the economic and social benefits that foreign investment brings, both home and host states confer beneficial treatments to the investments, including various investment safeguards contained in investment treaties. So that would be the legal legitimacy. I also address a wider public interest legitimacy in the paper, but I would not devote my attention to this aspect, at least in this presentation. The framework is built on four considerations. First, what all investors have in common is that investors seek to generate profit, while second, they aim to minimize their risks by using legal safeguards available, and they do so ideally to the maximum protection offered by the relevant treaty or by the relevant law. That would be the third premise. Fourth, since investment is a highly complex activity that integrates various interests at the same time, or interests that actually change over time during the course of the investment, the framework includes and streamlines these interests by always focusing on the dominant interest at a time, but focus on one dominant interest that does not necessarily invalidate the presence of others. Next slide, please. The typology is, and the framework consists of four different investor interest types, and they are divided based on their considerations with regard to risk aversions, their sunk costs, profit orientation, and legal conflict avoidance. The interest that I propose to distinguish between are the skill-intensive investor interest, labor-intensive investor interest or investment as such, regulatory framework-dependent investments, and indirect and financial market-oriented investments. As mentioned above, the idea is that any foreign investment would be able to fall into one of these streams based on the legal interest that they would follow. The framework distinguishes between the most risk-averse, for instance, on the left side, those would be those skill-intensive investment that require a high developed legal framework in order for costly investments to be invested into and to be maintained in the territory, to the most volatile on the right, which would be, for instance, a portfolio investment, not necessarily a direct investment per se, but the framework also caters to the classification of investment that would be considered a portfolio, not only direct investment per se. Next slide, please. To briefly depict how streamlining of investor interest could work in practice, I picked a case, an exit case of investment arbitration where investor utilized all four types of interest at the same time. In this particular case, it pertained to an expropriation claim of an investor that invested in Hungarian Budapest airport, and the work pertaining to an airport terminal, while also utilizing an SPV in a third jurisdiction backed up by promissory notes. By utilizing different forms of investments, we are able to see that following all of these paths, the investor needed to secure different legal risks and therefore to use different legal safeguards. Next slide, please. What is the actual impact of this proposal, and what is the benefit of this paper? This framework aims to provide for a baseline legal methodology that may be utilized by various stakeholders, namely policymakers, involved in operation of foreign investment. The identification of a dominant legal interest underlying each investment may clarify the investors as well as the host states' choices of legal instruments, treaty provisions, and investment policies while conducting or managing foreign investment. The proposed typology allows for a detailed understanding of investors' motives with regard to law specifically and not economy, as opposed to the theories that we know currently. And this in turn allows the host states to structure their substantive and procedural investment protection, depending on the type of investment that the host states wish to attract, as well as on the relevant public interest that they may want to protect in each of the areas. Only when policymakers understand legal repercussions of their investment policy choices will both home and host states be able to structure their substantive and procedural investment protection depending on the type that they wish to attract, and avoid, for instance, a focus on one type of investor as such. Furthermore, the proposed framework revolutionizes the calibration of public interest in the home and host states by offering a conceptual clarity, and that is done through understanding the impact of policy decisions on certain investors. Thank you.
Now I would like to shift a little bit the order, to introduce Dr. Chen Yu, the postdoctor, Doctor of Research at the National University of Singapore, to speak first, and then we'll come back to invite Dr. Ying Zhu to continue her talk. And now we see that actually Dr. Chen Yu, and she's been received her PhD degree from McGill University, and her research interest includes international investment and trade law, international adjudication, international relations, energy law. So we actually see another, great scholar in these areas of energy and also sustainable development. Her research has been published in various peer-reviewed journals, including ICSI Review, the Journal of International Dispute Settlement, the Journal of World Investment and Trade, and Asia Pacific Law Review. Her monograph titled Dispute Settlement and the Reform of International Investment Law, Legalization through Adjudication, will be published with Edward Elgar. So look forward to reading that. And Chen's topic today is legal stability and renewable energy transition in investment arbitration towards more deference to regulatory changes. So this sounds a very interesting topic, and we'll see how she will share the view with us. So now I'd like to invite Chen to speak, and the floor is yours. Thank you.
Thank you, Professor Heng Wang, for introducing me, and thanks to the organizing committee for inviting me to CIBEL's. Sorry, I think that's some problem with share screen. For inviting me to CIBEL's Young Scholars Workshop. It is my second time participating in this workshop. I benefited a lot from discussion last time, so I'm really grateful for this opportunity. Since I have already explained the background information in my video, so in my presentation today, I will just focus on the key issue of my research, which is investment tribunals' approaches to the issue of legal stability under the framework of fair and equitable treatment. Next slide, please. So just to give you a very quick recap of the background of all these disputes, between 1997 and 2007, the Spanish government implemented a series of regimes to stimulate investment in electricity power plants using renewable energies. And a typical incentive provided to these investors is feed-in tariff that is guaranteed above market price to ensure that the producers, the energy generators can sell the electricity at a higher price than the market price, and therefore to maintain a certain degree of profitability. However, after years of implementation, the government found that it was facing a serious problem of energy deficit, and it attributes these incentive schemes to this problem, and therefore it started to water down these financial incentives, and the most fundamental change to the regime was made between 2013 and 2014, when the government totally abandoned the feed-in tariff and replaced it with a market-based remuneration regime, and which consequently caused a significant drop of revenue received by those investors. And unsurprisingly, these measures, these changes attracted a large number of ISDS cases against the government. Currently, there are around 50 cases, and they are all under the Energy Charter Treaty. A key ground invoked by those investors is Article 10 of the Energy Charter Treaty, which requires the host state to create stable conditions for foreign investment and to provide fair and equitable treatment to foreign investors. Investment tribunal's approaches to the issue of legal stability vis-a-vis the state's right to regulation is far from consistent. And in my paper, I summarized them into 3 categories. The first is what I call the fundamental change approach. Tribunals adopting this approach recognize that states can change the regime, but it highlights that it should not be radically altered compared to what the investor could have expected at the time of investment. Many tribunals adopting this approach rely heavily on a broad interpretation of the notion of legitimate expectations, and these tribunals had no difficulty in finding that Spain has violated its obligation of legal stability. Next slide, please. And the second approach I call the reasonable change approach. It is looks like a more refined version based on the fundamental change approach, because tribunals tried to take into account more of states' right to regulation and slightly shift away from the exclusive focus on legitimate expectations. And commonly adopted approach to analyze the reasonableness of change is the well-known proportionality analysis. However, although this framework seems to provide more balanced or contextual analysis, it doesn't necessarily lead to more differential results, because tribunals may still attach significant weight to the impact on foreign investors in its balancing exercise. And apart from proportionality analysis, I think it's an interesting framework. It's proposed by the Renmin Tribunal, which has a 7-factorial framework. And I think these factors are basically a synthesis of the factors mentioned by previous tribunals. Next slide, please. And the last approach is legitimate expectations in its strict sense. Tribunals adopting this approach focus more on whether the host states had made any individualized specific commitment to the foreign investor. And if it has not made such commitment, tribunal will not find that the obligation of stability exists. And next slide, please. So overall, I agree more with the third, which is also the most restrictive approach. I argue that for the fundamental change approach, the way tribunal interpret stability is heavily linked to a very overly broad interpretation of legitimate expectations in the very early unrefined ISDS decisions. And I think that is problematic. And with regards to proportion analysis, I share the concerns of many commentators regarding whether it is appropriate for investment tribunals to conduct this exercise, and especially with regards to highly complex polycentric issues like renewable and energy transition policy. Even if proportionality analysis were to be adopted, I argue that more deference should be granted to the host state when tribunals review whether the issues, the measures are taken for legitimate purposes, whether they are necessary or whether they are suitable. So that's my overall argument, and I look forward to your comments. Thank you.
Thank you very much, Chen. I think that's been a great presentation for us to look into the crucial issues. How do we provide stability, and also dealing with those issues like renewable energy transition in the complex, arbitration processes regarding investment. And now we are happy to see that Ying's returns and that will enable us to listen and understand the critical issue about how do we deal with investment law and environment governance. So Ying, now the floor is yours. Thank you.
Thank you very much, Professor Wang. I'm sorry for the technical issues. So my paper discusses a bottom-up dilemma between international investment law and environmental governance. It argues that the global environmental governance has a bottom-up trend towards polycentric, adaptive, and participatory decision-making processes. And this creates an emerging tension with international investment law. My paper responds to the rich literature on how to balance investment and environment under international investment law. We can see an increasing number of cases where state environmental measures were claimed by foreign investors as a violation of investment treaty obligations. The literature mainly frames this problem as a tension between states' right to regulate vis-à-vis their obligations to protect foreign investors under investment treaties. I try to add a governance dimension of this problem. I argue that in many cases, it's not the challenge to environmental regulation by itself that violates investment obligations, but it is the governance process in which such regulation is taken that causes the problem. In my paper, I define governance as a broader concept than the regulatory conducts of governments. Environmental governance involves active participation of both state and non-state actors, including local communities and NGOs. And its norms are invented and adjusted in a dynamic and adaptive way. And its governance structure is often multi-leveled, involving local, provincial, regional, national, and international scales. This governance process is in tension with international investment law, which functions through a strong treaty regime that takes force in a contracting party in a top-down and integrated way. For example, most investment tribunals allow states to regulate polluters. But if different environmental standards are adopted between federal, state, and local levels, that may violate the consistency and transparency requirements under the FET standard. For another example, most investment tribunals would have no problem if a host state enacts a formal environmental legislation or changes its environmental laws. But they may blame host states for adopting a novel environmental standard in a court or in an environmental impact review panel, even if the host state argues that such innovation is to fit a new situation or in response to local communities' opposition. I name this tension as a bottom-up dilemma. In this dilemma, states face conflicting obligations regarding the allocation of governmental authorities, the frequency of norm evolution, and the inclusiveness of decision-making. The paper examines the ISDS case law to illustrate how this dilemma is reflected in cases and assesses whether the ongoing reform of investment treaties can solve this dilemma. It concludes that most current treaty reform efforts do not give sufficient deference to the features of environmental governance, including the actors of governance, the levels of governance, and the modes of governance. To remedy this defect, the paper proposes future treaty makers and arbitrators to consider environmental governance features in the making and implementation of investment treaty obligations. So that's a summary of my paper, and I appreciate this opportunity to present here and welcome all the comments. Thank you.
Thank you very much, Ying. I think that's been like those kind of the concise, and very useful presentations by you and also other two co-panelists. I think that's give us the audience, pretty good sort of idea of what you are trying to present, in your great analysis, in your great work. And now we are going to a very exciting part of our session, and also I'm very glad, to have introduced our excellent Sable colleague, Dr. Jonathan Bonnitcha, of our Herbert Smith Freehills Sable Center at UNSW Law Justice. And Jonathan has been recently promoted as an associate professor in UNSW's Faculty of Law and Justice. And he's best known for his fantastic research on investment treaties. And his research is obviously a cutting-edge one, also considers interrelationships between different systems of foreign investment governance, including investor-state contracts, national investment laws, national investment dispute management agencies, and international principles such as the UN guiding principles on business and human rights. And I should also add that actually Jonathan has been the recipients of the recently, Journal of International Economic Laws, John Jackson Awards. So that evidence, the fantastic work he has done. And from 2020 to 2025, Jonathan is the chief investigator on the ARC, Australia Research Council funded project, China's Belt and Road Initiative, a new model of economic governance, along with, Sable colleagues, myself, Kun Fan, and Ross Buckley. Within this project, Jonathan is leading the research stream on investment states contracting between Chinese firms engaged in outward foreign investment and the government entities of the host states in which they invest. So now I would like to have a great pleasure to invite Jonathan to share your view and the comments on the presentations. Yeah, the floor is yours, Jonathan. Thank you.
Thank you so much, Heng, for that introduction. It was excessive. I didn't expect you to read out quite so much material, but I'm very grateful for it. But mainly, I'm just quite excited to be here at this Young Scholar Workshop. I still think of myself as a young scholar, but I realize that very quickly my work is getting old and out of date, because here we have 3 great papers, all of which have picked up ideas that I guess I've thought about in a very early sort of form, but each of these papers develops those ideas with a lot more rigor and detail and explores the implications. So I feel surpassed in the best possible way. And I think they're 3 interesting papers because they all relate to each other, actually, especially the final 2. But I see connections, quite close connections between all 3, which makes my job as a commentator easier. So what I'll do is I'll just give some brief comments on each paper, including 1 or 2 questions, and then hopefully I'll also have the chance to join in the wider discussion at the end, perhaps by posing further questions. So, Dominic, this is a really interesting paper, and you're grappling with quite an important general problem, I think. So the general problem being this sort of ongoing sense of disconnection between scholarship in the field of international business studies, international management, international economics, and what investment lawyers talking about. And it seems sometimes like those two bodies of literature have almost nothing to do with each other, even complete ignorance that those bodies of literature exist. So I think the general instinct that's animating this paper to connect these bodies of literature is a really important and powerful one. But it also comes with some of its own challenges. And I guess the high level challenge that I wanted to suggest as a comment, but also put to you subsequently as a question when we get to the sort of general discussion, you might respond to this. And it's the question of what is typologizing for? What does it get us? So in the work that you refer to, particularly Dunning's work and subsequent scholars in international business studies, they're really trying to answer a set of questions about why do foreign investors engage in foreign direct investment? So it's a set of explanatory questions, and typologizing was a step towards a richer explanation for a set of empirical phenomena in the world. And that's not to say that these typologies don't potentially have normative implications, but they are fundamentally non-normative exercises. They are, at least as a first pass, they're explanatory exercises. So in your presentation, you sort of made the point that, well, we need to understand the drivers of foreign investment from the perspective of a firm, and including some differences in the drivers between firms engaged in foreign investment in different sectors or different situations. And I guess the big question that I have is about the movement to normative conclusions, because that's gestured to in your paper in the section 4, which is sort of sketched out, but you're going to propose to develop it. And again, in your presentation, you sort of ended up with this sort of gesture towards the normative, saying, well, treaty drafters, government officials, they should be aware of these sorts of things and they're relevant to the drafting of legal instruments. But I wanted to know a lot more about how they would be relevant. So are you suggesting that certain sorts of investment should be excluded from the protection of investment treaties altogether? They should just be outside scope, or that the levels of protection, the levels of substantive protection should be calibrated differently depending on the sort of interests or the sort of investment involved, or perhaps compensation standards would look different. So it wasn't actually clear to me what a lawyer or a policy official would do with this typologizing. That's the high level question, and it's a genuine question that I'm interested to hear your views on. I also have a sort of set of comments that are sort of drilled down in a lot more detail, and perhaps it's best we pick this up offline, sorry. But I do have a set of questions about the way you've constructed your typology. I mean, the one that really jumped out at me was your grouping of resource exploitation as labor intensive investment. I mean, when Rio Tinto or BHP builds an iron ore mine in the Pilbara in northwestern Australia, they're doing it because the iron ore is there, not because labor is cheap. So the fact that resource exploitation in your typologies collapsed into labor intensive. In fact, a lot of resource exploitation is very, very low levels of labor intensiveness. It's highly, highly capital intensive forms of production. So that was, I guess, something about your typology that I sort of instinctively was quite resistant to, and I think you've lost something really important there. I have also some questions about your regulatory framework dependent category, and this is a link to the normative, because some of those sorts of investment, particularly intermediary structuring for tax minimization purposes, I mean, the regulatory framework there in a specific sense is hugely important as an explanatory factor of why is all this investment taking place, at least in an accounting sense, in Luxembourg or in Ireland. I mean, it's to do with regulatory arbitrage, tax arbitrage, but whether that means that treaties should be in any way informed by those sorts of questions is really a different sort of issue. And then I guess maybe the thrust is to say, well, the whole point is these sorts of investments shouldn't be protected. Perhaps that's where you're going with it, but I'd like to hear you articulate that. Moving on then to Chen's paper, this was another great paper, and I think for me the Spanish solar cases are so useful as a kind of field. I mean, they're obviously important in their own right, the amounts of money at stake, the number of cases, the policy interest, you know, this question about energy governance. These are hugely important issues, but from the perspective of the scholar, we've also got a set of essentially identical factual scenarios, and that gives us a real opportunity to unpick some of the doctrinal moves that are going on in the decision or the decisions. So in other contexts, we have the problem that maybe decisions are reasoned in a certain way, and we just don't really know how much actual work the reasoning that's written into the decision is doing, because the facts are so different between cases, and we always have this problem in legal scholarship that certain aspects of a reasoned decision could be just some sort of ex post justification for a determination that's really been reached on other grounds. So the Spanish solar cases are great because they control for that. We know the cases are basically identical. And so if tribunals say different things and then reach different conclusions, we can be really confident that these doctrinal differences actually matter, that we can see how they matter. And, you know, the paper shows a really good command of the detail of those cases, of the underlying factual sort of setup, and also the way that different tribunals have approached that. So congratulations. Just on the three-way classification of different approaches to stability or legitimate expectations, which sort of merge into each other. I mean, one initial comment I had, or perhaps a question, and you can answer it as a question, is about the final category. So legitimate expectations in the strict sense, which depend on individualized commitments, you seem to be suggesting, as well as the most normatively attractive conception, that this is also the narrowest conception of stability. And I wondered if that was always necessarily the case. So we might imagine a hypothetical scenario where individualized commitments have been given in a particular sector, perhaps to many different actors. And then all of a sudden, under this approach, if the key doctrinal switch is whether or not there has been an individualized commitment, if there has been an individualized commitment, we could end up with a very, very high level of commitment to stability under that approach. So that's, I guess, a question for you about whether you see it that way and whether that is a problem with your framework or something you're comfortable with. Moving to, I guess, the bigger questions, so on the paper as a whole, I think in your evaluation of the three different approaches, the part that I found most compelling was your criticisms of proportionality. And the reason I found that most compelling was because it was clear why you thought the particular approach was doctrinally problematic. So you criticized proportionality on the basis of, you know, the lack of institutional competence and technical knowledge of the tribunal, also perhaps a lack of embedding. So it's really clear to me why you thought proportionality was a problematic doctrinal technique. In relation to some of the other discussion, it was less clear to me why one approach was better than another. So I share your instinctive view that the fundamental change approach is far, far too broad. It captures far, far too much. It doesn't give states the space they need to adapt and evolve policy regimes over time. So I agree with you. But aside from that instinctive sense that that's just goes too far, I was wondering if you could develop a sharper sense of the why that underpins your instincts about why some approaches are better than others. And that really links to my final point, which is about reform possibilities beyond doctrinal interpretation of fair and equitable treatment provisions. Because if we look at current treaty practice, we've got the new EU practice, expectations are sort of in there, they're in CETA as a cross-cutting factor, but breach of expectations is not in itself a basis for breach of fair and equitable treatment. So already we've got, even in the EU, we've got treaty practice just moving away from all three of these approaches potentially. And that's even before we get to practice in ASEAN, where we have the minimum standard of treatment tied to fair and equitable treatment, tied to denial of justice, potentially much narrower, although we don't know how tribunals would handle that. We've got Indian treaty practice. There is no fair and equitable treatment in there. So we've got this whole discussion on foot about, I guess, a much wider menu of treaty reform options. And I was interested to hear your reaction about whether those options would be better than any of the three you consider, whether they go too far or not far enough. And finally then to Ying's paper. So I loved the way this paper was theorized. I really was convinced by your sort of analytical move to get away from this kind of right to regulate regulatory space discussion, which sort of presupposes a unitary conception of the state where regulation is just something that happens once as a one-off move and everything is sort of fairly institutionally simple. So a lot of the academic scholarship, as you know, up till now has been framed in those terms. And I think your engagement with scholarship on environmental governance is really, really helpful here to say, well, regulatory processes, if we look at these cases, they involve more institutional complexity. The different agencies of government, sometimes they're working at cross purposes, they have different mandates, they have different scope of federal or state jurisdiction. That's entirely normal. We've got policy learning over time. We've got changing priorities over time. We've got new information. We've got civil society actors. And if we think about scholarship on environmental governance, then these things are generally seen as normatively positive. They're seen as an attractive part of environmental governance because it enables learning and development over time. And you set out the, I guess, the tension between that way of thinking about policy development and governance with the much more mechanical way of thinking about stability that is embedded in a lot of investor state tribunal decisions, and I think in the treaties themselves. You set that out really clearly. So I was really impressed by the theorization of this paper, and I encourage you to I'm not sure if it's already accepted for publication, but if it's not, I'd really encourage you to publish this. Most of my questions were about the implications of this analysis, because it seemed to me that your analysis raised some quite big questions about the design of investment treaties, what they're intended to do, and how arbitrators think about their interpretation and application. And having sort of thrown up what seemed to me some quite big questions about the functioning of the regime, the set of reforms that you seem to be suggesting or moving towards are surprisingly, to me, they seem surprisingly conservative. There's sort of discussions about the better drafting of exception clauses, clarification of, substantive standards of protection. I mean, I agree that these are all would be useful improvements, but having, I guess, laid out what seemed to me a much more fundamental challenge or tension within the regime, I guess my question to you is whether the sets of reforms that you discuss in the paper, and you might like to speak to this when you respond, because in your presentation, I know you didn't have time to sort of deal with that part of the paper, whether they're really adequate to address the scale of the tensions that you laid out. So 3 wonderful papers. It's just a pleasure to be part of this discussion, and I will, I guess, give it back to Heng. Perhaps we give each of the speakers a chance to respond before we have questions from the floor.
And thank you. Thank you so much, Jonathan. I think these your comments are extremely useful, and also I like the way where you put all of them in the same picture, and that's really super helpful. And I should also remind we'll definitely give the chances for each of the speakers to respond to Jonathan's comments. I hope there'll be an opportunity for you to further elaborate your analysis and deepen your analysis in that regard. And also I also would like to remind all speakers that we also have some questions in the Q&A channel, so you can have a look at that if you haven't got time to do so. So that's also something we can discuss later. So with that, I think maybe I would like to invite each of you to give feedback to Jonathan's comments. I think of something like 5 or to 7 minutes, if that's okay, unless you see any urgent need to expand a little bit, that'll be fine as well. And then we also would like to go to the session which will look into some of the questions we have in the Q&A. I know that's also Jonathan mentioned that you may have further questions on the presenters, and that will be a time where we have a more broader discussion. Okay, so with that, maybe may I invite Dominic to start, and then we'll follow by Yu and also sorry, Chen, and also by Yim. Thank you. So let's firstly invite Dominic. Thank you.
Thanks a lot, Jonathan, for your comments. This is extremely helpful and extremely constructive. If I may, I would respond to the first and the third question altogether, because I understand that they both would go under a more of this normative category. So what is understanding actually good for, and can we turn it into normativeness in the end? So what I would say is that, and perhaps it might be counterintuitive, and that would deserve some explanation. I think that the fact that it's not normative is in fact a strength of the typology, and the reason is that that as soon as there is any normativeness embedded in the typology or in the framework, it would seem to suggest that there's one preference of investment over the other. So, for instance, if I would argue that countries should focus on skill-intensive investments, that's not available to all countries, because not all countries have highly developed either investment treaties or national laws that would be able to actually provide the stability for investments that have high sunk costs and where investors would not actually even invest because it would be too risky. And the legal safeguards, it's specifically for that reason that the legal safeguards would not be tailored to the skill-intensive investments. However, the ambition is, in fact, to have it very neutral and to have it inclusive, not only for state economies, so to cover home and state economies, whatever investments they are exposed to, but also to different investors who might be interested in investing in different areas of law. So again, any normativeness in terms of you as an investor should do this, or you as a host state should do this, is not necessarily, it is not a good point as part of the framework. I see it as a methodological tool to understand and to streamline. And the next step, I agree, for it to be effective, there needs to be this normative aspect. But that would be, and unfortunately that's still relatively underdeveloped in the paper, but I can also develop this second step where I see that the normativeness would strike in. And that is in fact something that I encountered in practice, and whether it is for research or I would say more importantly for international organizations that in fact struggle in terms of analyzing home and host states investment policies. If you look at international organizations like World Bank that have high interest, and a lot of their work is in tailoring and actually facilitating investment policy work, and dealing with government officials. There's no such, there's no universal framework that could be used. So what these agents do in general is that they create their own framework, which, however, is not necessarily tested in the outside area, and of course that might lead to further negative aspects, that, for instance, all of the agents use different, either different typology, or that it leads to a certain implications that the countries have to face within different frameworks, be it international organizations or legal ones. So where I would see this is in the second step, a very practical implications to be used either for, home states or to in international organizations. For instance, I can see it in practice now when we're thinking about the reform of investment protection in the European Union. It is clear that so far the investment treaty protection system offers better protection when it comes to expropriation standards, and also more effective dispute settlement when it comes to certain countries of the European Union. So the question is, if we take this apart, we will be left with a system where I would argue that the labor-intensive investments are very well protected, but skill-intensive investments within the internal market of the EU will be located in countries with long tradition and with stability, but not all countries are the same in the internal market. So for instance, the Central and Eastern European countries that do not have such a developed framework, and the framework is unstable, if we take away the dispute settlement system, which is not important for regulatory framework dependent investors, and it's not important for indirect and market-oriented investors, because these investors are conflict avoidant. It's easier if you have a bank or let's say an investment firm in Cyprus, it's easier just to transfer, not only for tax reasons, or Luxembourg. You just take it from Luxembourg to Ireland, or you take it elsewhere. So dispute settlement, for instance, which I would consider higher, has a higher degree of protection in investment treaties. If we take it from the system in the post-ECMIN context, then we are left with a good protection for labor-intensive investments, but not skill-intensive investment, which, of course, in the normative sense, are the ones, skill-intensive investments are the ones that bring the most benefits to home as well as host state countries. They are typical for a high degree of various spillovers to both of these economies. So that would be a practical implication. But of course, it could be any sort of either tailoring a certain investment policy to any country. So it's a more of it's more of a methodological tool, which should be neutral and then particularly tailored to whatever the needs are. Again, intra-EU aspect that I mentioned is very specific, but so will be any other aspects that any other country would have to face. As for the other comment on resource intensive and labor resource intensive investments, this is in fact something which again economists would have a different explanation for, and that is the presence. That is that the presence is in fact explained by the existence of the resource itself. And for law, I actually categorized it as a skill-intensive investment, but also I mentioned resource exploitation in the paper in a labor-intensive investment. The reason for this is that with resource investments, it is extremely tricky in terms of how you categorize it and which part falls into which interest is dominant to the specific investment. For instance, building a pipeline requires a lot of investment with high sunk costs. So that I would consider as a skill-intensive investment, not only because it's high sunk costs, but also there's a high degree of expertise as well as high expectations from the stability of the host state economy as such. Whereas, for instance, mining coal as a traditional resource intensive investment, I would consider as a labor-intensive, where it's not necessarily that difficult to move machinery from in worst case should the investor face expropriation, for instance, or other issues to move from that country, and there's not much skill in terms of in terms of how you're actually exploiting the resource as such. But that would be very different depending on the character of the investment. Thank you.
And thank you very much. Thank you very much, Dominic. I think this has been very helpful feedback. And also now I would like to also invite Chen to respond, and then followed by Ying. I hope that maybe Jonathan, if you have any further comments, you'll be more than welcome to share that after three of them make their feedback. Yeah. So now I would like to proceed on to invite Chen. So please go on.
Thank you, Professor Heng Wang, and thank you very much to Jonathan for your very thought-provoking comments. And I totally agree with you. I think around 50 cases against Spain is a fascinating case to observe how investment tribunals can interpret the same clause and pretty identical facts in quite different ways. And with regards to your comments about my three categorization, actually, I must admit that I also have some skeptical with regards to the third approach, legitimate expectations in a strict sense. As I mentioned in the paper, if we interpret, especially Energy Charter Treaty if we understand it from the perspective of treaty interpretation, it explicitly refer to the term stable, and therefore if we adopt this quite a narrow approach, it would undermine the role of that term in treaty interpretation, which might be against the rule of treaty interpretation as required by Vienna Convention on Law of Treaties, Article 31. So that could be a problematic issue with this approach. And also, as you mentioned, it's the definition of specific commitment is also quite tricky. In the Spain cases, if we adopt this approach, it appears to give the most deference to the host state. But if we are in another case, for example, the host state made very individualized, explicit and very broad commitment to the foreign investor, it could lead to some horrible results, because tribunals will just say what it's committed, and it will not adopt any proportionality analysis, not balancing anything. So that is also a risk with this approach that I think I must address in my paper revision. And I think what you mentioned, the second point about these reform options, really it is really inspiring for me. Maybe I can restructure my argument, because previously I was basically comparing these three approaches and choose one that I think is better. But now maybe I can jump out of this framework and just say that all of them are problematic, and maybe the future of this issue lies in the revision of treaties or modernization of treaties without the support of treaties like more deference, for example, carve-out clauses, and maybe more explicit reference to the goal of sustainable development and host states' regulatory rights. Without all this textual support from treaties, the side on the dispute settlement, what tribunals can do to modernize, to address these issues, is actually quite limited. So maybe I can mention in my paper that should be the focus of the future development. That's my reply to the comment. Thank you.
Thank you, Chen. I think it's been great. I like the concise feedback you've provided to the questions. And now I would like to invite Ying to respond to the questions and the comments of Jonathan. And after that, I will invite perhaps Jonathan to add any points you have, and then we'll proceed on to some question already in Q&A. And also before I invite Ying to proceed on, I would also encourage all the audience, if you have any question, please don't forget to raise that in the Q&A session, and we'll try our best to accommodate that. So with that, I would like to invite Ying to proceed on.
Thank you, Professor Wang. Thank you very much, Jonathan, for your very insightful and sharp comments on my paper. I think you get to the point that I am going to even further than I intended, because I am trying to get a broader conclusion on my second paper, because this paper focuses only on the interaction between investment and environment. I think that maybe my conclusion in this paper can also be applied to other public interest fields, such as public health and cultural heritage, etc. So whether it can be transplanted to other fields, I am still not sure. So I need to do more research to get a broader and more macro rather than micro conclusion, because I think that maybe the current debate on the right to regulate is a little bit limited. We should go for a broader concept of the governance process, but whether that process can be applied to other public fields, this is what I am currently researching on. I think even in the field of the interaction between investment and the environment, some tribunals have already figured out that actually we should not only focus on the regulation by the state, but we should look at the the political and economical context of such regulation. Some tribunals mention in their decision that if we want to examine what is the legitimate expectations of foreign investors, we should look at not only the legislation or the regulation by the state, but we should look at the political, economical context of the country. We should look at the historical context when the investment was made. So I think some tribunals have realized that, but there is no not a very structured theoretical framework that can explain that. So my paper tried to build a framework on that. So I think for the conclusion of this paper, I did provide some very detailed the treaty makers to conclude some new treaties that take into account the environmental governance issues. For example, when they conclude when they drop the non-discrimination clauses, such as the national treatment or the most favored nation treatment, I encourage them to clarify the treaty clauses to include not only the in-like circumstances terms, but also to ask the future tribunals to compare only those investments that are subject to the same regulatory processes and the same impacts on the local communities. And also for the fair and equitable treatment clauses, I encourage future treaty makers to explicitly provide that some features of environmental governance do not by themselves violate the fair and equitable treatment clauses. Now there are some treaties that would say that the change of the law of the whole state does not by itself violate the FET clause. But actually, the state not only changes its environmental laws, it also changes its environmental standards in the law enforcement processes, such as in the administrative and adjudicative processes. So I would encourage the tribunals and also the treaty makers to take that into account. And also for the indirect expropriation clauses, I prefer to clarify such a clause and to say that the investors' expectations should be confined, and it should be examined in the context of the environmental governance processes. So those suggestions are indeed a little bit detailed, and I am looking forward to expand the conclusion to fit for more scenarios, for example, in other public interest fields. Thank you very much for your comments, Jonathan.
Thank you very much, Hing. I think that's also fantastic to have all three of you to have the feedback, to the comments raised by Jonathan. So maybe Jonathan, if you don't mind, to give some short, comments, or do you have any other points you want to add on that?
Nothing to add at this stage, Heng. I think maybe we can. We have about 10 minutes. We can go straight to some of the questions in the chat.
Okay. Thank you, Jonathan. I think it's been great. So now we would like to, proceed on to the Q&A. We already have some questions. I noticed that we have, 3 questions for each of the speakers, but also, yeah, Jonathan, you also get a question, at the end of that, along with the speakers. So why don't we see that we have about 10 minutes? So maybe we could have, each of you about 3 minutes, to have give the feedback to the question. I think. If I can start with Dominic, you see the question in the Q&A. I guess I will not repeat that, but that's about question about how do you elaborate, conceptualization, how that affects the investment rules, and then we'll proceed on to Chen, about the question to you and also to Ying. I also would like you to bear in mind we have a question to the general, to the whole panel about what are how technology may affect investment law. Like digitalization, because we see more of those digitalization in the COVID era, and also including regulation. So with a specific question to you and also a panel-wide question. So I would like to invite our 3 panelists to give a short response, no more than 3 minutes. And then also Jonathan, if you can, add on that. And then we will proceed on to maybe Jonathan to announce the winners of our award. Yeah, I guess. Yeah. So. Dominic, the floor is yours. Please go on. Oh, I think we have lost. I think Dominic experienced some technical issue. Okay, so now why do we invite Chen, if you can? And sorry for asking you to be a kind of firefighter to help us. Yeah. So Chen, please.
Yeah. So I thought the question is twofold. One is about the appellate court, and the other is about whether the other states or other approaches. Since I have mentioned the treaty approach in my response to Jonathan's comments, so maybe I will just address the appellate court part. Actually, a couple of months ago, just published an article expressing my skeptical attitudes towards the establishment of the investment court. So, so answering this question, I might say I don't pin much hope on this mechanism in addressing these problems. Of course, the investment court can solve the problem of consistency in this around 50 Spain cases. If we have one investment court with 10-year judges, they may not develop 3 approaches to the issue of legal stability. But the problem is that the controversies or the inconsistencies arise not only from different decision makers. It lies in the fact that the issue itself is quite controversial, it's quite complicated, and it is not underpinned by any shared understandings between different commentators, scholars, arbitrators, and the states. If we have one tribunal or one court and it set a binding precedent on this issue, it may be challenged greatly by states or by other actors. So it is another legitimacy problem, which I think is more severe than the problem of consistency. So so in all, I think the problem still lies in the investment treaties. If we want consistency, want to really address the issues, we need to reform the treaties rather than relying on the investment court to solve all the problem. Thank you.
Thank you. And thank you, Chen, and thank you for the feedback, and also it's very helpful. And now we are glad to see that Dominik is back. So I would like to invite Dominik to respond to the question about how the framework you propose apply to investment rules as well as any trend of investment practice, and may help the framework may help explain, but also to the general panel wide question about how digitalization or technology may affect the investment law. So the floor is yours, Dominik.
I might have already explained how I would see it work, for instance, when it comes to the reformation of, or actually thinking of about reforms in the intra-EU aspect. And maybe what I would add on top of what I already mentioned is that I think we usually underappreciate the level of or the tools that could be helpful to policymakers. I think a lot of the issues, such as, for instance, instability in legal environment, as well as instability or, let's say, inconsistency of decision-making processes between different levels of governments and agencies, is due to the fact that there's not good understanding of the implications of the decisions that we're making. And sometimes it could be, of course, it could come from, there might be different interests underlying those decisions as well. But often I see that as a good value. For instance, when it comes to the conflict management and decisions, from my experience, we have seen in many countries that there is no level of information, for instance, of the local governments or the local agencies of the fact that there are investment treaties. So just in, I see my contribution in providing a more of a universal tool that could be helpful in streamlining these thoughts, notwithstanding the decisions that it might actually lead to. So that's where I see the practical implications. And in terms of the technology, I think that with regard to my contribution, I think that it would relate more specifically to new requirements from legal standards applicable to technological investments as such. but not necessarily go in the direction of a skill-intensive investments, which I have characterized as typically high-tech investments, but also more in the direction of these so-called born global firms, where in fact there is a technology underlying an investment, but there is not necessarily a presence in one country or the other. It's operated, for instance, from one country, but the presence is throughout the entire world. So I see that this is something that this has not necessarily been foreseen in terms of investment treaties, but ultimately having no presence does not necessarily expose the investor to a regular environment of the host state and doesn't actually perhaps necessitate protection when it comes to expropriation, but it certainly necessitates protection safeguards in terms of market access and for instance, transfer of funds. So this is where I see that the streamlining of thoughts is certainly beneficial because it allows for considerations pertinent to specific aspects of investment treaty protection. Thank you.
Thank you very much, Dominic. And also, it's very helpful to see the practical application of your framework, to those practices. And now I'd like to invite Ying, and Ying has questions about, how do you think one could further integrate investment environment because they may have a tension between them, and also what are the national approaches to those issues, in major economies like the US and China. I think they are pretty interesting about China, and in practice and trend in this regard. And of course, we have a panel wide question. Yeah, so it would be great to see your thoughts. Yeah, in the floor is yours.
Thank you very much. Thanks for the question. For the first question, I always believe that the interaction between investment and environment has two folds. One is that they are in tension. This is most scholarship works on now, because there are increasing number of cases, especially ISDS cases, where states' environmental measures are claimed by foreign investors as a violation of the investment treaties. So now we can see the tension between investment protection by investment treaties and environmental regulation, mainly in the domestic level. But I think what is mostly neglected is the other side of the problem. That is, actually, we need investment. We need foreign investment to promote clean energy, especially to combat some global issues like climate change, because some developing countries and the least developed countries do not have enough financial resources to solve the problem. So foreign investment is not by itself against environmental protection, but on the contrary, in some especially crucial global crises, we really need foreign investment to go to the place where we need to. So this is kind of related to what Dominic's paper talks about, whether we should define investment in a way that it can promote sustainable development. For example, we can define the investment in an environmentally friendly way so that green investment will receive better treatment than other investment. So I think this is a very important issue the current literature should develop. The other question is about how the major economies deal with the tension between investment and environment. So I think there are different approaches, especially between some traditional major capital exporting countries such as US and EU, and on the other hand, the new power like China. So for US and EU, traditionally, they have been capital exporting countries for a long time. So their investment treaties are adopt very broad and vague terms in favor of investor protection. And the current reform is to carve out states' regulatory space from such broad protection of foreign investment. So at the core of this reform is to carve out the state's right to regulate from the liberalized treaties. But for China, the situation is different. I am also working on a paper on how to green Chinese investment treaties. Chinese investment treaties go through 4 generations ever since the opening up policy in 1970s. And most Chinese investment treaties were signed at a time where China was a major capital importing country rather than capital exporting country. So those treaties are quite conservative. If we measure the greenness of investment treaties by how large the regulatory space the state have, you can see Chinese investment treaties are quite green, even though there is not enough green language in it, because it is quite conservative. It has qualified national treatment clauses, or even it does not have national treatment clauses. So it actually gave a lot of space for the host state to regulate and limit foreign investment. So I see the future trend of treaty reform in China is different from that of the EU or the US, because it is how to liberalize those treaties at the same in a way that is sustainable. So I would call it like sustainable liberalization approach. So that's very different, and that is more complicated than making a liberalized treaty more conservative. So that is my answer. Thank you.
Thank you very much, Yin. I think it's been very helpful, and also for sharing your views about the China's investment treaties and practice and the future. Now I would like to invite Jonathan to share. Firstly, I guess to give the feedback, to the question we have about the future of investment, and also how technology may affect that. Thank you.
Well, I'm very conscious of time. We have, I think, 3 minutes left. So I guess I'll just observe that if we think about investment treaties' traditional function, the investment protection function, that is, it's remarkable that we've had digital technology has been a really major part of the global economy for at least 20 years now, probably 30. And off the top of my head, I can't think of any ISDS claims that relate centrally to digitalization or digital technology. So one thing that's really interesting in that is the relative, I guess, disengagement of the traditional investment protection function of investment treaties from digitalization. And if we look at the sorts of claims that we continue to get in ISDS, they are across a very broad range of industries, but they're things that we would recognize as economic sectors from 50 years ago or more: the financial sector, mining and extractives, infrastructure development. These tend to be still the largest sources of investment treaty disputes. Turning then to the 2022 Sable Young Scholars Prize. These were all great papers, but the prize this year goes to Ying Zhu for her paper, A Bottom-Up Dilemma, International Investment Law and Environmental Governance. Congratulations. And with that, I'll pass it back to Heng to conclude the proceedings.
Thank you very much, Jonathan, and for your feedback, and also congratulations to Yin and for getting the award. It's really fantastic. And I would like to, I'm conscious of time, also to conclude the session by, at the very beginning, I would say congratulations to all the speakers. I think all of you has done a fantastic job. I think we have going through the process, and your work has really stands out. So that's fantastic. So well done for all of you. And we would like to really extend our gratitude to all the speakers, for sharing your fantastic research with us, and which help us to understand, the future of international economic law, particularly regarding investment law. And also, I would like to especially thank our commentator, fantastic colleague, Jonathan. And I know that you have take your time out of busy schedule, to read the papers and share the very, valuable comments and thought-provoking one, and makes the events a really valuable one for the participants. Yeah, and also with that, I also would like to thank our audience, for being with us and also to interacting with us, including the questions, and that's really helpful for us to have those interactions. And I would like to extend a special thanks to also our Sable administrators, and to Fiantra, to Hannah JS and Sophia Bai, and they are worked very diligent and very tirelessly for our events. With that, these events will not be possible because many of these behind scenery efforts are really most appreciated. So, and also would like to take this opportunity to remind our audience that we also have a upcoming CIBEL JCI-CL conference on October 20th of 2022. JCI-CL refers to the Tsinghua UNSW Joint Research Center for International Commercial and Economic Law. We're looking to the trend of international commercial and economic law of 2022. And we'll have speakers from both USW and Tsinghua and others to join us and to share different aspects, including competition, trade, investment, and so on and so forth. So with that, I would like to conclude here and thank you, everyone. And you can find out the events or future ones via CIBEL website. With that, I would like to conclude here. Thank you, everyone.